Welcome to the League of Women Voters of Utah's annual legislative wrap-up. I know the media has been saying this session was a snoozer, but they must not have been in our committee meetings. Our thanks to Cynthia Phillips for leading the team during this session. And of course, we encourage you to join us as it never ends. Tonight, we'll hear from 4 of our Action Corps members about what happened and what we need to watch out for. We'll start with Helen Moser, who will speak to us about the many iterations of voting bills. Then we'll go to Linda Smith, who's kept close watch on the legislature's attacks on the judiciary. Elizabeth McKnight has followed healthcare issues as well as bills targeting immigrants. And Norma Wills was focused on natural resources and, of course, the Great Salt Lake. We will try to answer your questions at the end of the session, so please add them to the Q&A function. Thank you very much, and now let's hear from Helen.
And hopefully you can see my screen at this point. Awesome. So this cartoon, and it was AI generated, lots of fun, but it captures the atmosphere that the League faced in monitoring and making our voices heard, or attempting to do so this session, in the broad areas of voting and elections. A number of lawmakers acted on what we would consider national and local conspiracy narratives. They claimed non-citizens were voting, our voter rolls were inaccurate, vote by mail fraud, distrust of institutions, and distrust of citizens' voices in our own government. So these claims and the resulting distrust generated a large volume of legislation, with some lawmakers sponsoring multiple bills, going out of their way to arguably signal to voters their true conservative colors in advance of this year's election.
Helen, I'm afraid your share has stopped. So do you want to try that again?
Sure. Are you seeing it now? Okay, let's try advancing it. Or not. Sorry guys, I'm getting an error message. And let me see if I can get back. I am not able to advance it. Let me go ahead and ask that we suspend presentation for a moment. And Linda, if I could hand it back over to you to share more information, and then we will come back to me and I will troubleshoot on my end.
Thank you, Helen.
Thanks.
We'll be back to you soon. And Linda, let's go to you next. Thank you. We really do know technology.
I'm thinking you should now see my screen. We're going to talk about.
Not yet, Linda. Can you make sure you've got the share on again and your slideshow?
All right.
And your
Now
slideshow.
you should see it.
And your slideshow.
Do you not see the first slide?
We see all of your notes on the side, so you need to
play from the start.
Yeah.
Okay.
So there we have bills on the courts. We're going to talk about what passed, what didn't pass, some constitutional, some unconstitutional. The session began with me not representing the League, but just me, myself, lawyer Linda, former law professor Linda, writing an op-ed in the Tribune regarding the 4 bills that were out at that time. One, to expand the Supreme Court from 5 to 7 judges. Another, to change the Constitution to allow the governor to ignore our excellent merit selection system and just pick anyone he wants as the next judge. Another, to amend the Constitution to, again, ignore our excellent judicial retention system and just allow the legislature to call for a snap election to remove a judge for certain nefarious reasons. And then finally, a bill to require that judges pass the retention election with 67% of the votes. The first thing that happened was SB 134 zoomed through the legislature, expanding the Supreme Court from 5 to 7 justices. This was despite the fact that the judiciary did not want the Supreme Court expanded. They had wanted 7 new trial judges, 2 new commissioners, and 1 new Court of Appeals judge. Well, the legislature got generous and gave them 3 new trial judges, not the 7 they'd asked for, and threw an extra Court of Appeals judge. So this was an expensive change in the court structure and not one the courts had wanted. Nevertheless, we'll soon see 2 new Supreme Court justices. Applications were due last Friday and for district court judges this Friday. So my next step was to write a letter to the editor asking the governor to make sure that he picks new Supreme Court justices who are as excellent as the current ones in terms of their educational background and their experience. And if he doesn't, then the charge of court packing with political cronies might have some validity. New bills appeared. There was a bill we didn't even focus on, Senate Bill 270, which was suggested by the Utah Bar Foundation to create a new debt collection and housing court with the idea that the court that is operated in the 3rd District in Salt Lake City with volunteer lawyers would be expanded to welcome all the people having their debts collected and being evicted throughout the state. So that bill apparently was unopposed by anyone and passed, and we're going to have a new debt collection system and new volunteer opportunities for lawyers. Then there was some desire to reform the excellent Judicial Performance Evaluation Commission that we have. Apparently, they aren't doing enough checking up on judges, and the legislature needed to give them new tasks. After substantial amendment, JPEC is now required to hold the votes on retention in an open meeting, but individual members' votes are going to remain private. JPEC is required to study whether it's feasible to review judges as to whether their cases are, the cases they decide are reversed on appeal for abuse of discretion, which when I testified, I told them would just be confusing because abuse of discretion doesn't really mean anything within the legal world. Then currently JPEC surveys lawyers, jurors, court staff about the performance of the judges, but this bill requires them to now also survey parties who may have some feelings about what the judge just did in their case. So they'll now survey parties to the extent practicable. And then there'll be new standards for efficiency in the appellate courts finishing their cases quickly enough. Because the legislature has been concerned that the appellate courts are taking too long to issue rulings against them. There was a bill regarding transparency, information access, and transition. And this bill also was substantially amended. It started out by requiring that all court hearings be live streamed. Now, there are live streams at the legislature, but there aren't as many courtrooms at the legislature as there are throughout the state. And that would have been terribly expensive and ridiculous expenditure. So it turned out to be now every court proceeding is public and is recorded, audio recording. And so now the law says that anybody can get access to that audio recording. The Judicial Council is going to study whether that should be free or what the cost should be. And then the Judicial Council is required to maintain a website that would allow the public to search and access all public court records without payment of a fee. That's going to be a challenge for the courts, but I actually personally think that's a good idea. I can access the court's website because I've got access through the law school, but the public should be able to access these records. Judges now also have to file an annual disclosure. What was deleted from this bill was what had been put in there that was unconstitutional. It was a provision that would prohibit judges who step down from the bench from working for a law firm that is suing the state for, and that prohibition would be in place for 2 years. Now, it's really hard to find a large law firm that isn't suing the state in some regard or another. But what's unconstitutional about that provision was the Constitution clearly says the Supreme Court by rule shall govern the practice of law. And the Supreme Court already has a rule that says what former judges may and may not do. They may not represent anyone in connection with a matter in which they participated personally and substantially as a judge. Well, that wasn't good enough for the legislature. They wanted to win here. And so they negotiated with the courts, and the courts have amended their Rule 112 to say, in addition, an appellate court will not appear personally before their before the court for 2 years, which doesn't really prevent them from being hired by law firms or working on cases just from appearing personally. So no citizen is denied representation that they would request. Then there was a bill about judicial districts. This is a picture of our judicial districts, and the bill was going to combine 7 and 8, combine 5 and 6, and combine 1, 2, and 3. It's not a crazy idea to combine 7 and 8 because the judge has to live in the district, and Moab is the big city here. And it's not crazy to combine 5 and 6 because, again, St. George and Cedar City are the big cities, and that would allow judges to be, there'll be enough lawyers in the district to hire one as a judge. But combining 1, 2, and 3 is crazy. 3, which is the Salt Lake district with Tooele and Summit, has something like 45% of the new cases. Looking at last year's statistics. And if you added District 1 and 2 to that, it would be 69% of the cases. So one mega district would be 69% of the cases compared to 8%, 4%, and 19%. So that was crazy. I sent that analysis to all the lawyers in the legislature. And I don't know whether that was helpful, but Senator Weiler withdrew this bill after the lawyers and the bar opposed it. Then there's another bill that was also unconstitutional that didn't go forward. It would have allowed for a referendum that would overturn a Utah Supreme Court opinion that declared a law unconstitutional. Well, Matt McPherson thought this would be fine because Article 1, Section 2 says all political power is inherent in the people. Well, that's political power, which is legislative power. And that's why the legislative branch has the legislature and the people. But the judicial department, which is not political power, decides whether something's constitutional. Anyway, McPherson didn't quite understand that this would be unconstitutional, but it didn't go forward out of rules anyway. Then the biggie. There was a proposal to create a new court, just like the housing and debt court. This would be a constitutional court, a constitutional trial court to hear all cases in which a statute or other action are alleged to be unconstitutional. And it would be new judges appointed to this court by a new nominating commission. And everyone thought this was the worst possible court packing maneuver. It was strongly opposed by the courts, the bar, the public. I testified against it. And ultimately, the bill was amended to provide for 3-judge panels of existing district court judges, requiring the judges to be from 3 different districts and allowing cases to be sent to these panels within 45 days of the bill's passage or within 45 days of the case being filed or being amended. Interestingly, the amendment provided no standard for what cases should go there, but the only way a court went there is the state as a party would transfer any case it wanted to. I told them in the committee hearing that this would be unconstitutional. You can't have one party picking courts and not have the other party having a say, but they passed it anyway. And then as soon as this law was passed, the AG immediately transferred 4 cases to these 3-judge panels. The redistricting case, the abortion case, Utah Physicians for Healthy Environment case about water to the Great Salt Lake, and an Earth Justice case for youth complaining about climate change. The plaintiffs in all 3 cases immediately filed writs in the Utah Supreme Court seeking to declare this transfer unconstitutional. The arguments were the ones that I'd made, that this violates the open courts, due process, uniform operation of laws to allow only one party to pick the transfer. And the other argument that I hadn't seen is that 3-judge panels are themselves unconstitutional because in 1896, when the Constitution was adopted, there were nobody understood a trial court to be anything other than a single judge. Anyways, these writs are still pending with a briefing schedule that's going to require new arguments to be submitted by the 17th and the 19th of the month, and then a reply argument. But facing this litigation, the legislature came back in the last 2 days of the session and amended another bill to fix the unconstitutional issues that I had identified for them, and to change the bill to say any party can request the 3-judge panel as long as the case involves challenges of constitutionality and seeks declaratory injunctive relief. But it then provides a backstop of the new constitutional court if the 3-judge panel is held unconstitutional. So what will happen? Stay tuned. I have my opinions about what I'd like to happen, but we'll see. The other bills that we started out the session with, the constitutional amendments to allow the governor to appoint whomever he wants, to allow the legislature to call for snap elections, and to require 67% of voters to say yes, never got out of rules. So I don't know whether I should take personal credit for that. Anyway, that's the end. Watch for our study on the state of the judiciary, and we'll be working on that starting next Wednesday. And show.
Thank you, Linda. And I will say that we and the legislature are apparently quite lucky to have Linda around to tell us what is constitutional and not, because in March of 2014, the legislature saw fit to get rid of their constitutional notes in their bills. So they never know. Okay, thank you, Linda. Again, Q&A for after the whole session here. Helen, are you ready now, do you think? All right, you can unmute yourself.
I am, thank you. Peg, if we can go to the second slide in the deck, that would be terrific.
Talk for just a second. We are struggling with this for some reason.
Certainly. Okay, I can share with you that we had a huge task simply because of the volume of bills that came. The league monitored 26 bills across 6 committees in what I divided into 4 policy categories. They were elections, registration voting, initiatives, and election oversight. Of the ones we opposed, 42, of these we opposed 42 rather, and of those bills, 45% of those bills passed. So tonight, if we can get this slide deck working, I want to focus on key bills, some that passed, one that failed, and others were altered via kind of late session tactics by the legislature. Okay, next slide, Dan. And if we could go to slideshow view, that would be great. Right there. Okay, perfect. So in this slide, you see all of the bills we were monitoring, and whether we opposed, supported, monitored, and of course, green indicates they passed, red indicates they failed. So a lot of them were tried and did not pass. So we're going to start with two of the most controversial bills. First, and if you could advance a slide, Peggy, is HB 209 voting amendments. So HB 209, and we'll go from kind of key provisions to potential impact. HB 209 requires voters to provide documentary proof of U.S. citizenship to participate in state elections. The Lieutenant Governor's Office would also be required to cross-check or audit existing voters using federal and state databases and notify those citizens whose citizenship could not be verified. If a voter cannot immediately produce documentation, they could still vote in federal races, but not in state or local races until proof is provided. That effectively creates a two-tier or bifurcated ballot system starting this year. So let's talk about the potential impact and concerns. The League opposed the bill because Utah already has multiple safeguards to verify voter eligibility. Federal and state laws already require voter registration applicants to attest to their citizenship under threat of criminal penalties when registering. County clerks already have tools and processes in place when requiring them to investigate citizenship status at the time they actually set up their registration or when a concern arises. And if a voter is flagged in the Lieutenant Governor's recent audit or at registration, they must prove their citizenship within a period of time or risk, again, losing their ability to vote in state elections. This means that essentially, if the database, and we frequently use the SAVE database and other databases, but if it's incomplete or incorrect, it's going to actually flag the voter. And this disproportionately impacts Utahns who may not have ready access to documents such as passports and updated birth certificates. And the estimated is 1 in 10 U.S. citizens, and by the same token, in Utah, 1 in 10 citizens. It would disproportionately affect naturalized citizens, tribal members, seniors, disabled voters, students, rural residents, military voters, low-income Americans, and anyone whose legal name no longer matches their birth certificate. These voters would face expensive and really time-consuming hurdles to obtain and submit the required documentation, including fees, delays, and out-of-state record requests. So the practical result of this bifurcated ballot system could be increased complexity for election officials, raising the risk of errors, rejected ballots, confusion for the voters, and without any kind of demonstrated improvement in our election security. So voting by non-citizens, as we've heard from the Lieutenant Governor and Secretaries of State and Lieutenant Governors across the country, voting by non-citizens is incredibly rare and typically by mistake. So our own Lieutenant Governor reviewed 2.1 million registrations recently and found only one instance of a non-citizen registered who did not vote. So it's proof that Utah's election system is safe with current safeguards that already worked. Also, Kansas and Arizona implemented the similar bifurcated system and required documentary proof, and they ended up blocking tens of thousands of eligible American citizens from registering and faced costly litigation. So instead of building voter confidence in our system, the bill encourages distrust, suspicion, and intimidation of the voting process. So it's going to likely, the worst impact is really reduced participation in state and local elections, which means state legislatures, state executive, state school board, ballot propositions, and local elections like city, county races, local school board, and judicial retention. And the outcome of these races has such a critical impact on Utahns' lives. So it would really be a shame if these continue to be hampered by low turnout. Peggy, if we could advance to the next slide. And we're going to next discuss SB 153, voter registration records. This one caused particular concern with the Lieutenant Governor's office, as well as the League and other allies. What happens is it shifts Utah's voter privacy network. So voter records classified as private prior to April 6 will become public unless the voter qualifies as an at-risk voter. A state notice will be sent to voters whose records were previously private or withheld, letting them know about the change. And then the deadline for individuals to apply for at-risk status is right around the corner on May 6th, and the voter must provide proof to the county clerk. And only with that will additional privacy be verified and the record classified accordingly. So standard voter records would be subject to disclosure starting May 25th, and also petitions gathering signatures must warn all signers about disclosure of the records, and this treats it the same for at-risk voters as it does for regular public voters. And for the at-risk voters, the only change is that it would disclose only the voter ID and the signature date, but not the rest of their address and other information as it would for a public record. And then there would be restrictions and criminal penalties for misuse of this data. So what are the implications? Right now, 40% of Utahns, including myself and many others, have opted to have our vote record private. We're going to lose privacy protections by default. It's likely that there are folks who are going to miss notices, there are going to be some administrative barriers, and it's going to result in unintentional disclosure of information, such as name and home address, if they don't take address by May 6th and provide the necessary proof to be classified as an at-risk voter. And the proof raises the threshold for privacy protection, but it may exclude voters with legitimate safety concerns who can't provide that information to the county clerk. And so these are folks who may fear for their safety, but they haven't had any kind of a occurrence and filed a police report. So once a voter's record is public, several data fields will become available for public inspection. So this includes name, residential address, their party affiliation, their birth year, and a lot more. Then even though there's specific restrictions on how that information will be used, and there are criminal penalties that are established for misuse, once the voter data is made public, and it's publicly available, again, enforcement against misuse like data scraping and targeting can be really difficult. And then the other thing is that participation in petitions still expose some identifying information tied to political activity. So there are going to be a whole host of folks whose civic participation in petitions is going to be discouraged. Can we have the next slide as well? So let's talk about SB 194. This is the one that seemed to be a boogeyman that kind of disappeared after several substitutes. So SB 194, election modification, was an omnibus bill. It was a massive piece of legislation that combined provisions from multiple bills with elements of last year's HB 300, HB 361, HB 209, and SB 153. And it was incredibly complex to review, and for those of us who are monitoring as well as stakeholders who would be impacted to really assess what was going to happen. And it made it very, very difficult to fully evaluate its impact. So fortunately, there were multiple substitutes that scaled it back significantly, allowing some of the other bills like HB 209 to carry the weight. And aside from some lingering concerns that we have regarding having to opt in to receive ballot by mail, it made some pretty significant changes. So mail ballots still going to be an ID requirement. Vote by mail becomes request based in 2029, and we've still got to include our last four digits of our ID or social security number, or documentation, or risk ballot rejection. The opt-in to receive mail, again, will continue to be we'd have to opt in every 8 years. And it's going to reduce participation amongst those who are really infrequent voters. With ballot verification procedures, poll workers must verify not only ID numbers, but continue to do signatures, which is actually a good thing. It will increase administrative complexity, but it certainly benefits the county clerks who are concerned about not having that. Still has a ballot cure process, allows voters appropriate amount of time to correct rejected ballots. But it also does some new things. It introduces a conflict of interest avoidance plan for the lieutenant governor. So there were concerns about election oversight by the lieutenant governor, who would be an elected partisan office holder, particularly during her campaign or whomever's campaign later on. It removes election officials' names from ballots and envelopes. They can no longer put their name on that, and that's intended to prevent some perceived endorsement or influence in when they send out election materials. It also creates penalties for misuse of election information, harassment of officials, and then it requires that the county clerks have neutrality requirements. In other words, they can't alter procedures to favor one candidate or one measure. And then lastly, it allows campaign funds to be used for security expenses, and it just reflects kind of the growing safety concerns for candidates and campaign staff. So now let's chat about, and if we can advance to the next slide, thank you. And I apologize, this is like an eye chart for you guys. So let's briefly look at 3 additional bills and want to just share with you some of the late session tactics that shape their outcomes. So first, HB 479, election code modifications. This would have proposed significant changes to Utah's vote by mail system. It would have required that most voters initially who receive a mail ballot to return it in person and show valid ID with limited exceptions. The subsequent substitutes added in an opt-in requirement where voters would have to indicate in advance how they plan to return their ballot, and limited drop boxes with limited and very restricted hours. At each drop box, they would have to have 2 election officials present to check the ID of the person who was dropping it off. So the bill itself was estimated to cost as much as $10 million to deploy. And despite substantial opposition in committee, the bill passed the House. But it was held in Senate committee by the co-sponsor and never advanced, effectively ending it for the session, or so we thought. So let's talk about HB 311. HB 311 began as a modest election administration bill, and it was supported by the county clerks, and it simply maintained the use of signature verification to confirm voter identity. However, 2 days before the session ended, the Senate replaced the bill in its entirety with a substitute, completely changing the title and the content for the purpose of funding an election study. So the bill now provides $100,000 to UVU's Herbert Institute to study vote by mail, security, in-person voting, and possible ID requirements to use drop boxes. So these are the same provisions that were introduced in HB 479. The findings of the study are supposed to be presented no later than the October interim meeting, and the results could definitely shape legislation in next year's session. And then lastly, there's HB 242, initiative and referendum signature removal. So the original bill focused on regulating paid signature removal gatherers, including providing them training, it had compensation rules, it had penalties for misrepresentation, and along with a notice that they had, or along with a requirement that they had to explain to a person who was rescinding their signature, that removal of the signature could keep a measure off the ballot. And it received a unanimous vote in the House, but in the final Senate deliberation, a substitute was proposed, which included banning prepaid postage for signature removal requests. And that change directly affected Better Boundaries, who've been directing signature rescission efforts on Prop 4 repeal, and had been providing voters with postage paid envelopes in order to submit their requests. The amended bill was quickly passed and was signed into law by Governor Cox the very next day, and it goes into effect immediately. So, taken together, these bills are some of many that really highlight several trends from this session. We see a lot of flexing of muscles by some Senate power brokers. We saw a lot of late stage substitutes with limited deliberation and major policy decisions being made very late in the process, and some pretty hardball maneuvering by the legislator to get their way. As those tactics become more common, the legislative process becomes even harder for the public to follow, let alone influence, and that further erodes trust in how our decisions are made. Let me have you just advance to the next slide. So many of you probably caught this in the Salt Lake Tribune, and it speaks volumes, as always do Pat Bagley's cartoon. It tells it all. So I added the caption, but for advocates like the League, our community allies, and citizens who are passionate about issues and who dutifully contact their legislators and who show up to testify, this can leave us feeling like the legislator is clearly continuing to ignore the will of the people. So our focus has always been and remains ensuring that voting and election policies are fair, it's secure, and it protects our access and maintaining citizens' trust in our democratic system. So we'll continue with that as our intended objective. So with that, I will hand it off back to Kathy.
Thank you, Helen. You can tell Helen had a heavy lift in this session. And fortunately, she was there all the time, but we were fortunate to have allies in coalitions and other LAC members. So this is why we need all of you. We cannot depend on one person to figure all of this out. And this is an existential issue for our state. So thank you, Helen. Okay, now let us move to Elizabeth McKnight. Elizabeth, are you ready?
Hello, I am out here. I will see if I can run my video and my slides at the same time, and I'll turn them off if I can't. So let me share my screen. Let me see if you can see that. This worked pretty smoothly a little while ago, but let's see if it still does. Okay. Does that look okay to you all? All right. So I'm going to be talking about a few high-profile bills from the 2026 session, and I'll be focusing on some that would regulate immigrant services, some that would regulate access to healthcare, and a few that will be doing both if they passed. Let me then click here. Okay. Oops. I think I skipped ahead too far. Shoot. Okay. I did say shoot. I'm having a little bit of a challenge, but now you're getting to see a preview of my slides. Okay, here we go. One of the things I tried to do as I was sitting in on sessions was really look at how the League of Women Voters impact on issues helped us to think about some of the things that were coming up for us and help to monitor. Let me start first with legislation, immigration, and focusing on one bill that really did generate a lot of consternation, a lot of drama, and unfortunately, a lot of concerns for those directly affected by it. House Bill 88, Public Assistance Amendments, was brought forward by Trevor Lee. The original version of the bill planned to sunset the Children's Health Insurance Program, required public services like the food pantries, housing agencies, clinics giving out free vaccines, and other tax-supported public services first to verify the legal presence to receive those public benefits. Unfortunately, as proposed, it would have shifted the entire cost burden of enacting the legislation to local community providers who would have had to figure out, say, in a small food pantry staffed by volunteers, how to check on citizenship status at the same time that they were trying to meet the needs of the people coming into them, people with children, make decisions about whether or not to give out food on the fly. And as it turned out, by the time this bill actually came to the committee meeting, House Law Enforcement, it had already undergone 2 substitutions. And by the course of the evening and the time Representative Lee presented it was already on the 5th substitute. So one of the things that did change in the course of a very short evening was the provision to sunset the Children's Health Insurance Program was dropped, but the majority of the onerous parts of the bill passed forward. House Law Enforcement voted 7-3, despite some, vocal public concerns that were raised. There were a lot of folks from both sides of the issue testifying, and those opposed included Voices for Utah Children, Protect Medicaid, Utahns Against Hunger, and many members of the public with lived experience. So it was a little bit heartrending to see that happen. When the bill reached the House floor, it met further strong opposition from House members on both sides of the aisle. Many of you may actually have heard some of the statements made. For instance, Cheryl Acton had a statement about how concerned she was that the bill really conflicted with the principles, Utah principles of welcoming immigrants. And she likened the situation to a Sermon on the Mount situation where Utahns would be asked to turn their back on strongly held principles of welcoming and helping those in need. Others from both sides of the aisle talked about Lady Liberty and the poem, "Give me your tired, your poor, your huddled masses yearning to breathe free." So very dramatic, very concerning. The outcome was on the February 23rd, when this bill was on the House floor, is that the bill was circled. However, it did not end there because the next day we did have a miraculous transformation of the bill. Representative Peterson's bill, HB 386, Immigration Amendments, was amended to include most of the provisions of House Bill 88 within the context of that bill, so that now we were faced with a bill that prevented in-state tuition for immigrants without legal standing, or appeals, a guest worker program, the Utah Pilot sponsored resident immigrant program, as well as the items that Rep. Lee had originally planned. The bill was then did pass on to House Business and Labor 9-0, and then came to the floor and again passed. But what happened, and we don't know all that went on in the Senate, it did actually stall in the Senate, not wind up passing. And the word is that Stuart Adams may have taken a really strong stance opposed to the bill as actually being contrary to the Utah Compact. At any rate, there was no Senate sponsor who attached their name to the bill, and so it wound up in the House file for bills, dead bills. So that is one immigration bill with implications both for healthcare and causing a lot of problems for those who are immigrants. Moving forward, some other bills that came forward this session. International money transmission brought forward by Representative Gishas was planned to impose tax on international transfers unless the transaction could be associated with a legal standing. A Utah driver privilege card's not accepted to avoid the tax on these money transmissions. Representative Lee also brought forward a bill on human trafficking, transporting, and harboring. Representative Peterson put together H. Bill 244, employment amendments, which would have prevented employers from cooperating with law enforcement. Again, this bill did not move very far. Employment verification, House Bill 294, which would have required any employer with 125 or more employees to be registered per the status verification system, and employees to be verified and subject to criminal prosecution if there was fraudulent ID use. And HB 287 immigrant driving amendments would have repealed the Utah driving privilege card altogether, which is the bill that does in fact benefit all of those who may wind up in a collision, because it allows immigrants to actually purchase insurance without a legal presence, but allowing them to drive responsibly with insurance. Finally, Trevor Lee's immigrant amendments would have limited the ID banks could accept, and again, prohibiting those without legal presence from sending money transfers. All of these bills failed, and that's good news, I think, for all of us. But again, probably we'll be needing to watch during this next few months to see if any of these issues do rise up again. Let me turn now to one bill that did pass, and this here is the unlicensed driver amendments. Similarly, focus on appropriate ID if a driver is stopped, and limiting to these three forms of identification. Otherwise, having the driver subject to risk of seizure of that vehicle. You can see how if Trevor Lee's HB 287 had in fact passed, it could have had even more negative financial impact on immigrants, since that driving privilege card would not have been considered a legitimate form of ID. And there's some risk that this bill can increase the potential for racial profiling. Anyway, this is something that while it passed, we need to be aware of its impact, and again, maybe something the league will want to continue to advocate around. Now switching to healthcare access, a few bills that came forward this session limiting healthcare access. HB 471, social services amendments brought forward by Representative Monson. Probably the least surprising of these bills. It's really was meant to prepare the state of Utah for the full implications of having HR 1, the big beautiful bill, impact Utah social services. It rolls out work requirements for Medicaid, which are new, and may have the impact of disenrolling some of current Medicaid beneficiaries because of the difficulty in some cases of being able to document that that the work requirements are being met, gig industry or those who are doing infrequent work, picking up work as they can. It also did add some exemptions for beneficiaries who are unable to work. And among those new categories was those experiencing homelessness would not be held to the work requirements. But the bill did restrict both Medicaid and SNAP to citizenship or lawful presence. And the combined impact of those two provisions will be likely to decrease access to the programs and will overall likely reduce the health of the state. And the legislature is really hoping that the financial benefits to the state of dropping those, they're already considering that in their planning. The second bill here, exercise of religious beliefs and conscience amendments, has raised some real concerns. Senate Bill 174. This is a bill that makes it easier for procedure providers, as well actually as insurance companies and pharmacies, to refuse to support procedures that violate personal beliefs. While it doesn't have bearing in emergency care settings, it is expected to reduce some access and also payment for services. And those may be things like elective abortions, which is what was predicted, but also things as that we take for granted, like vaccination coverage, tubal ligation, vasectomy, depending on the personal beliefs of the providers involved. So concerning something that we'll be needing to watch. HB 174, sex characteristic change treatment amendments brought forward by Representative Shipp, prohibits providing cross-sex hormones, puberty blockers, this time to minors who are younger than 16 years of age or who have not yet received cross-sex hormones. This bill, again, received a lot of opposition. However, it passed quickly through both House and Senate committees and was passed out. So this is one that we'll be dealing with in the coming year. Okay, so all those things passed. Now, some bills, just a handful of things on the brighter side, maybe a little bit of innovative legislation this session. First, HB 71, Health Provider Directing Access. If you have ever been in the position of trying to find a healthcare provider who delivers behavioral health, mental health care, or looking for someone else, maybe a family member, to try and find someone who is available and is accepting new patients, it can be quite onerous. And that's because there are a lot of names still on those insurance provider lists that do not actually accept new patients. They're referred to as ghost providers. Representative Eliason calls it his ghost bill. And the requirements of this bill are that insurance companies and the insurance commissioner and others involved in the process have to work together to make sure that those lists are cleaned up of providers who aren't really offering services. If you as an insured individual cannot find a health provider that even though you're paying for it, that provision of this bill would allow for you to see an out-of-network provider and have your insurance cover it at least one time because of the difficulty currently of finding an in-network provider on many of those insurance lists. And then the bill will also pull a work group together to try and think forward about what's a better way to make the community aware of mental health care providers, building a state database, and a better user-friendly query tool. So this is a bill that, if it's enacted and successful, could really help to make it a little bit easier for those in crisis to find a timely relief for their symptoms and a good provider. Next, HB 9399, street medicine amendments, brought forward by Representative Clancy, really helps to put in place some standard requirements and a guide for those who are providing what's called street medicine. In other words, taking the care out into the areas where the homeless and others are living and unable or unwilling to seek care in an emergency room or other setting. One of the things that helps do is allow providers to use what they call long-acting injectables, so that those who've received health care can continue to follow up their medication without having to take something like a daily or thrice daily pill to manage their condition. And it's expected to really improve continuity and compliance with some of the care plans that are developed. So again, a good bill, kind of innovative. Hopefully we'll see some benefits from it. Finally, HBill 390, veterans, PTSD, clinical research. Again, kind of a new approach. Utah has a lot of veterans and has a very high rate of veteran suicide compared to national statistics. This bill will allow collaboration with Huntsman Mental Institute to run some studies and really explore the feasibility of some new treatments through psychedelics that are not currently in use, to try and help specifically with treatment-resistant post-traumatic stress disorder. And so, again, another bill that's worth following. Those all passed. Finally, reproductive rights. There are 3 bills that have been the focus of a lot of attention. They did not wind up passing. They all failed. But I think it's important to realize that a lot of the reason why these bills were defeated had to do with some great proactive work. For instance, Medicaid abortion payment amendments, the Planned Parenthood and other groups spent about a year educating our state legislators about the fact that Planned Parenthood clinics do much, much more than provide abortions. Their main focus of their work is really doing basic healthcare preventative medicine. And so when this bill is brought forward, that would have prevented a provider who had provided even one elective abortion from ever qualifying as an eligible Medicaid provider. It was helpful that all the representatives and senators were aware of the implications and what a large part Planned Parenthood and other organizations similar to that play in keeping our public health network in place. HB 315, human development instruction, again, failed. The bill would have required for all schools to provide a 3-minute or longer high-definition video. The Baby Olivia video is one that was suggested by the law, and each stage of human development to be portrayed. The problem is it was never approved through the system committee set up to approve the Board of Ed curriculum. Materials like this are also not supported by any evidence-based standards. For instance, the American College of Gynecologists rejected the videos as being not valuable information, in error, and really produced by an anti-abortion committee. That bill, fortunately, failed And then finally, HB 480, medical record amendments, would have required that medical charts when in the case of elective abortion, make a judgment between medically indicated abortions and those that were elective, which is really not something that a coding definition, which drives payment and practice, can easily differentiate. And so that bill went down again. That's a win for the state of Utah. And that is the end of the bills that I wanted to talk about today. I'll stop sharing and turn the time over to Norma.
Well, to me first. But thank
Oh,
you,
to you first.
Elizabeth. You've had a lot to cover, obviously. Some good news. I see some lawsuits perhaps in the wings on some of these, but you did cover a lot, and with all of your LAC members as well. Thank you. All right, next up, and finally, last but not least, let me put it that way. Norma Wills on natural resources. Norma. Norma, be sure to unmute.
Okay, is that better? Sorry. Anyway, thank you for the opportunity to talk about the natural resource bills that came through that legislature. First of all, I want to thank all the committee observers. We had lots of different committees to monitor, and Lori Jones, Carrie Doan, Joan Entwistle, and Shelley Stricker all contributed to those reports and to this presentation. So I guess my overall impression of the session is that it could have been a whole lot worse. We saw some really good bills that came out, and some not so good bills that were defeated, but others that did get through. So what I'm going to do is I'm going to focus on 4 different areas: the Great Salt Lake and other water bills, some of the bills that were proposed on air quality, public lands, and then lastly on energy. My slides are pretty detailed. I'm not going to go into each and every bill, but I just wanted to have it there to refer to if you want to look at any specific bills later on. You can check the recording. The bills that are shown in red, which you'll see, I think, on the next slide, are ones that I consider that would have long-term negative impacts on our environment and our ability to what's the word I want? Advocate on environmental issues. So let's see if I can start with Great Salt Lake. I can't seem to, oh, there we go. All right. So very late in the session, believe it was HB, let's see, HCR 30, I think was proposed on the last day of the session and breezed through both houses under suspension of the rules. But it settled a long-term ownership dispute with the federal government over the Bear River Migratory Bird Refuge. The good news about this is that the federal government has been monitoring or managing this area for a while, and the state will be able to use $60 million from that transaction to benefit Great Salt Lake. Another bill that will get more water to the lake is one that will give $2.75 million to encourage more split season water right leasing during the growing season. So farmers are pretty reluctant to um, to give up their water rights or to lease their water rights if they have to do it for the whole season. So with alfalfa farmers, sometimes they will have 4 or 5 cuttings. And if they can forego one of those cuttings and send that water to the lake, they can get some money for it and it benefits the lake. The other thing that could help is that they redirected many of the brine shrimp royalty taxes to a special fund for the Great Salt Lake. They used to go to an endangered species fund, but it seemed to make sense for the brine shrimp that live in the Great Salt Lake to be able to benefit the lake itself. There are other bills. Let's see, the inland port one. This was an interesting one. The big consideration there was that the water right, or sorry, new businesses in the inland port areas would be allowed to use pretty much as much water as they wanted, except in Salt Lake, where the city has a limitation of 200,000 gallons per day. And there was quite a bit of discussion over this because several of the inland ports are in the Great Salt Lake drainage basin. And so it would be nice if those limitations were could be imposed elsewhere. So the bill was substituted, and they came down on allowing the local municipal or water suppliers to set limitations within their own areas. So hopefully local influence will be more helpful in setting those limitations. Another one that will benefit the lake is the study of the wetlands in the first and second class counties. It will be looking at the extent of wetlands and their health. And so that can only benefit the lake. One bill that was very disappointing, oops, sorry. Went too far. One bill that was very disappointing was put forth by Senator Nate Bluin. And he worked with several students and younger voters on this bill to propose transferring $200 million from the Water Infrastructure Fund to benefit the Great Salt Lake in allowing the Commissioner's Office to purchase more water rights or to lease more water rights. This bill was heard in the Senate Natural Resources Committee, and there were 40 people that wanted to speak in favor of it. The committee ultimately decided to hold the bill and asked Senator Bluin to take it to the Water Development Commission, which he did. And again, that hearing, there were many, many people voting or testifying in favor of the bill. However, the Legislative Water Development Commission chose not to even vote on it and said to take it back to your committee. So it basically died at that point, which was very unfortunate. The bill I want to spend a little bit more time on, though, is HB 60, which is water rights amendments. What this bill does is it limits the criteria for protests to a water application and also redefines public welfare as a consideration of water in granting water rights. So the state engineer is the one that adjudicates these applications, and say it limits her ability to consider what is the public welfare. So in general terms, I mean, we can all sort of think what we know about public welfare, that maybe the water should be used for the most benefit for the most people. However, she is now limited to considering just the beneficial use of water and the quantity, quality, or availability of water. So they've taken away any considerations of environmental impacts that the change or the new water right might entail. And those effects cannot be considered. They have to be considered by other agencies. So this during the testimony for this bill, several groups again raised the question about who will now be able to challenge these water rights and on what grounds. So this could have far-reaching impacts down the road. So some other water bills that generally are helpful. New large data centers will have to report their water usage to the Division of Water Rights. They won't be identifying individual data centers, but the aggregate data will be available and hopefully put some pressure on these data centers to conserve and use water wisely. The legislature also set aside for next year's budget $5 million for pursuing, perhaps pursuing water disputes within the Colorado River Compact. So those negotiations are stalled right now. The 7 states have not been able to come to agreement, so the federal government will probably have to impose their own policy, and that could result in lawsuits between the states. And apparently Utah is expecting that because they're getting ready for it. There's one that was a bill, HB 400, that would have increased landscape water use efficiency, and that bill failed. And another big bill that failed, which was, I think, a very good thing, was an attempt to set up a new water management agency that would oversee large water projects. This was brought forth from Senator, oh shoot, can't think of his name right now, sorry. But anyway, that bill failed in committee. Let's see, another bill that I think got a lot of public interest was HB 501. And this was a proposal to require local water suppliers to collect a fee from their water users. And the reason for that, they had to use that money in local water projects. Initially, the bill would have kept these water fees in state control, but a later version of the bill allowed the local entities to retain those, would have allowed the local entities to retain those funds. So this was controversial because the fees were going to be based on the median income in a service area. And in some areas that would, of course, it's a very regressive tax, because lower income users would be forced to pay more than higher income, at least as a proportion of their income. So it would have been very, very detrimental to lower income groups. Let's see. Okay, there were a few bills on air quality. One that passed was fugitive dust mitigation amendments. And this allows the Division of Air Quality to impose a compliance fee on annual air pollution from aggregate operations. So these are the concrete and quarry operations that generate lots and lots of dust. And so now that gives the Division of Air Quality some funds, at least, to try to mitigate those effects. 2 other bills that failed, sorry, it's touchy. 2 other bills that failed one would have proposed a fee on older polluting heavy duty vehicles, which would have helped again with air quality impacts, and a bill to establish annual limits for PM2 emissions and nitrogen oxides also failed. This was put forth by Andrew Stoddard. Let's see. Okay. So there were a few bills put forth for on dealing with public lands. One of them that passed, which sponsored by Ray Ward, and it allows the transfer of small public land parcels that are adjacent to municipalities. And the reason for allowing that transfer is to build affordable housing. And it specifies affordable housing, so it can't be used for other purposes. Some people were wary that this might sort of be the beginning of a slippery slope because it seems our legislature is always looking for ways to increase their influence over our public lands. Another one that failed, but it would have, shoot, I'm so sorry. Another one that failed would have had a study to identify federally owned lands that could be used for outdoor recreation. And I'm not exactly sure why that one failed. That one seemed a little bit okay to me, but anyway, it failed. And the one that I'm really concerned about, again, is this HB 456. This was a Ken Ivory bill. When he presented it, he went through a painful history of public lands, federal lands, and Utah's not giving up authority over those lands. And I don't think he is entirely correct on those interpretations, but this bill will assert Utah's jurisdictional authority over lands controlled by the federal government in the state. It also directs the state to identify large-scale public lands, especially the forestry, fire, and sovereign lands, to identify problem areas that are prone to wildfires. There was a lot of emphasis on the problem we have with our mismanaged forests in the state, and this is a way to get a handle on those areas and for Utah to assert its authority over those forests. Let's see. So when he's talking about jurisdiction over public lands, federal lands, it includes land management responsibilities, generating income from renewable and non-renewable sources, collecting tax revenues, and maintaining road access. So his definition of jurisdictional authority is fairly expansive. And again, it's sort of the moving down that slippery slope for Utah to essentially take over all the federal lands in the state. So I was very concerned about that bill. On energy, there's a lot of bills. I think to summarize, I can say quickly that the state is going all in on nuclear energy. There are multiple bills that passed to set up the infrastructure for the state to develop these industries and to regulate these industries. I'm not going to go into those in particular because we have a clean energy study that is being worked on right now, and that should be coming out sometime this year. So that will provide much more information on the nuclear pieces of legislation. The other things, though, that were problematic in SB 238. This is a bill on transmission lines and the states getting involved in determining regional transmission networks. However, they slipped in a requirement for customers to opt into community renewable energy programs. This got a lot of attention, and there was a lot of public pressure both in the committees and public comment and emails and the whole shebang. And sorry again, Representative Albrecht backed down in committee and agreed to change it back to requiring customers to opt out if they don't want to participate in the community renewable energy programs. Geothermal is a hot topic right now. There are some studies going on in central Utah. There are efforts to develop geothermal energy, and so this builds SB 21 just was set out to clarify who owns those geothermal rights. They retained their geothermal rights for Sitla lands to remain with the state, whereas private property owners also own the geothermal rights underground. And then the other very concerning bill on natural resources is SB 234, Rulemaking Authority. And this bill will prohibit state agencies from imposing environmental and waste management rules that are any stricter than federal standards. And that is a concern because the federal government is in the process of downgrading lots of environmental rules and regulations, and it's especially apparent in the nuclear area that they are lowering their standards for safety and for safety. I'll leave it at that. Let's see. The other thing is that if a state agency wants to propose a new rule, they must rely on what is termed the best available science, which was not defined. So it's questionable as to who makes the decision as to what is good science. The rules can be made for harmful substances only if bodily harm is immediately apparent and not based on an increased risk. So we know that the effects of radiation and air pollution can take years to develop, and we would no longer be able to make rules based on good science that shows increased risk for certain harmful chemicals. And that to me is, again, very concerning, and I think will have far-reaching impacts on our state. And with that, I will stop.
Thank you, Norma. So obviously, everyone, this is a good news, bad news session. I almost don't know what to say. Let me ask you a little bit about nuclear. I know there wasn't a lot, but they seem to be taking water issues seriously. But are they
Yes.
concerned at all about the amount of water that would go into any kind of nuclear facility?
I think so, but I think the other thing is that this new technology, these small nuclear reactors that they're pushing, are at least touted as being much more water efficient. Some of them will use even the fuel, like the natrium plant that's going up in Wyoming. They will actually use the molten salt as a coolant as well as the fuel. So there are new technologies that may limit water usage for nuclear plants. But yeah, it's not at all clear how that's going to pan out.
Okay, well, there's a lot to digest here. What I'm going to do is ask everyone to just take a second and tell me what you think one thing is that we should be concerned about right now. And there is a special session we hear will likely be coming up. I will start with Linda Smith. And I'm sorry to catch you off guard, but if there's one thing that you want us to pay attention to, Linda?
Well, I think the consideration is judicial independence. And I think we hope to come out with our study in the not too distant future. And I think educating the public about the importance of judicial independence, about the excellence with our judicial selection and retention system, helping people understand how the judicial retention election goes. So I think we should be educating the public about the judiciary.
Okay, thank you. Helen.
Well, I think we're going to see continued attacks as we go forward. So HB 209 is kind of a mini SAVE Act, but I would right now kind of turn our attention nationally to the SAVE Act itself. And as we know, the Senate is hearing the SAVE Act, which already passed at the House, and it's taking place this week. And so even though we've been focused on states legislation and the impact here locally, that would have enormous impact, as we know, on midterm elections. And so if folks can certainly take action to contact their senator, and more importantly, if we feel like we're not going to have folks listening to us, alert your friends and family to do the same, who might live in areas where their their voice may have greater impact. But that to me is really the biggest thing that we should be mindful of right now about voting in elections.
Yeah, a lot of voter suppression in the wings. Okay, Elizabeth.
I think one of the things that I have most concern about is that Senate Bill 174, the exercise of religious beliefs and conscience, partly because it's the flip side of the Medicaid abortion bill that we saw was successfully contested and failed to pass because the community was really aware of the implications. I think with exercise of religious beliefs and conscience bill, we really were surprised, even though there are 7 other states in the nation that have a very similar bill that they are bringing forward. The bill was written largely by a lawyer in Illinois. And as the bill was being presented, some of our legislators said, so give us an example of something bad that this bill is going to prevent. And even though no one who was supporting the bill could articulate it, it still passed. So I think none of us from either party really had a good grip on what might happen, what kinds of denial of healthcare could come out of it. And I think it's just a missed opportunity that, I take blame too, that we're more aware of that. So I think that would be one thing that maybe this next year we can do some course correction. So that's my idea.
Thank you. And back to you, Norma.
Yeah, so I guess I'm particularly concerned about this headlong dive into nuclear energy. I think the jury's still out on whether these new technologies are going to be workable and whether they're going to be safe. And the fact that Utah apparently wants to run the whole gamut from mining to milling to fuel fabrication, running the plants themselves, manufacturing the parts, and then disposing of the waste. They want to do nuclear waste recycling. And I just think we don't need to jump into this completely at this point. I think there are too many unknowns, and also the fact that we're giving up our rulemaking ability to monitor those or to regulate those industries is very problematic, I think. I do think that there were a couple of instances where public outcry changed the the outcome of a bill. And so maybe if we are educating everyone about the what's going on with nuclear energy, perhaps there'll be a little bit more scrutiny before we just, I say, go all in.
Okay, thank you. We do have one comment which flipped over because I think Linda tried to answer it, but I'll try to summarize it. And the commenter is wondering, he or she did not want this to be a criticism of the league, but was asking why we're involved in so many issues other than voting rights, which is our, number one. But I will say, if you ever want to look at impact on issues, it is available. Well, Linda, you have to unmute yourself so they can see that. Impact on Issues is available online for free. You can get a downloaded copy. The League of Women Voters has been around for 106 years. We base everything we do on studies, and we take consensus afterwards to see what we are going to then take positions on and how we advocate. So this has been a long process. We have many, many things that we are interested in. We don't take them offhand. We take them very seriously, and they have been done very specifically with studies. Linda, did you have something else you wanted to say? I can't read all of your.
Yeah. Um, I just talked about impact on issues, but I think it's worth noting that one of the things the league is in favor of is civic engagement. And we don't have to be civically engaged just about voting. We can be civically engaged about many different issues. And I think we do recognize that when we're taking on environmental issues or other issues, we're not going to have any impact unless we work in conjunction with the other agencies. So it does give us an opportunity to network with the various different environmental organizations and to raise up our voices.
And I will say that we are lucky to have the kind of advocates we have in our membership. We've taken this year's sort of a dual strategy, not only to go and testify in person or online at the legislature, but also to send them letters, to send them to the committees, to send them to individual representatives, and to make calls. Maybe that's a triple threat there, but it works, and we need all of you to help us do that. Get onto our website, lwvutah.org, and look at our Take Action page. You'll see any kind of action alerts that we have there, specific bills that we've been following. I appreciate all of you. We will continue on. We are just about out of time, but thank you all, our guests and our presenters. Thank you.